You perform a complex procedure, the outcome is perfect and the patient is happy. Then years go by. Long after you've forgotten the details of the case, maybe even after you've retired, a letter arrives from an attorney. It's a lawsuit for a procedure you performed 5, 6, or even 10 years ago. This is the nightmare scenario for every dental professional. A long tail of liability that follows you for your entire career and beyond. So how can you protect yourself from a claim that arises long after you provided the care? The answer lies in understanding a legal concept that is often overlooked, and that is the Statute of Repose. Hi, I'm Warren Pearson, Vice President of Insurance by Dentists and author of Insurance for Dentists, Malpractice Edition. Today, we're going to be breaking down a critical legal concept, and that is the Statute of Repose. This is the hard deadline that can determine the fate of a future lawsuit against you, and it directly impacts the insurance you need to protect your career. In malpractice law, there are two clocks that run simultaneously. The first is the statute of limitations. You're probably familiar with this one. Its clock usually starts when the patient discovers an injury. Because a misdiagnosis or a failing implant might not be discovered for years, this timeline can be flexible and unpredictable. But the second clock is the statute of repose. This is the one you need to pay close attention to. The statute of repose is an absolute final deadline. Its clock starts ticking on the day the treatment was performed, regardless of when the patient actually discovers the harm. Think of it this way. If your state has a 2-year statute of limitations but a 4-year statute of repose, a patient might discover an injury in year 3. The statute of limitations would give them until year 5 to file a lawsuit, but because the 4-year statute of repose has already expired, their claim is permanently barred. The statute of repose is your ultimate backstop against ancient claims. So what's the problem? The problem is that these laws are a patchwork that varies dramatically from state to state. And more importantly, there are exceptions. The biggest one, minor patients. Now in many states, the clock on the statute of repose is paused or told until a child turns 18. Then the standard repose period begins. This means that for a child you treated at age 5, you could face a potential lawsuit more than 15 years later. This creates a massive decades-long liability risk that extends deep into your retirement. So how do you protect yourself? This is where your professional liability insurance becomes important. Most dentists have claims-made policies, which only cover you for claims filed while the policy is active. If you retire, sell your practice, or switch insurance companies, you are no longer covered for any of your past work. And that is why tail coverage is absolutely necessary. Tail coverage is an extension you purchase that covers you for claims made after your policy ends. The statute of repose, especially the long tail for treating minors, is the very reason you need it. Without adequate tail coverage that matches your state's maximum liability period, your personal assets and retirement savings are completely exposed. Understanding your state's statute of repose isn't just an academic exercise. It's the key to making an informed decision about the insurance that protects everything you've worked for. Alrighty, that's going to wrap up today's video. Thanks for watching. And if you want to dive deeper into this and other critical insurance topics for dentists, check out our book, Insurance for Dentists, Malpractice Edition, in the description below. Thank you so much for watching, and I will see you in the next video.